In a shocking Supreme Court opinion, attorneys for former President Donald Trump argued against bringing criminal charges against a sitting president, citing Trump appointee Justice Brett Kavanaugh. 7 weeks following a dramatic appeals court hearing in which Trump's legal team contended that a president could direct SEAL Team 6 to kill a political rival without going to jail if he was impeached and found guilty first, the Supreme Court declared it would hear arguments on the appeal on April 25. Trump's legal team filed a lengthy appeal on Tuesday requesting absolute immunity for the president in a case that has already been rejected twice and includes many of the same or comparable arguments. A former president is completely shielded from prosecution for actions taken while in office. The separation of powers and the executive vesting clause are the primary sources of criminal immunity. This court has continuously held, both before and after the president leaves office, that Article 3 courts cannot sit in judgment directly over the official acts of the president. This ruling dates back to Marbury and extends to Fitzgerald. Furthermore, based only on his official actions, the courts are unable to hold him in criminal court and put him in jail. But there's no talk about SEAL Team 6 or killing domestic political adversaries. However, as Maggie Haberman and others have pointed out, the submission does rely on a number of quotations from prior law review articles written by Kavanaugh. To put it concisely, a president who is worried about a criminal investigation that is still ongoing is almost certainly going to do a worse job as president. Separation of powers throughout the 44th presidency and beyond. Brett M. Kavanaugh, 93 Minnesota L. Rev. 1454, 1461, 2009. A president's prosecution or not is, in essence, a political act that cannot be avoided or minimized. The President and the Independent Counsel Brett M. Kavanaugh, 86 GEO, LJ 2133, 2159, 1998. This insight also holds true for past presidents, and it particularly holds true for a past president who is the front-runner to succeed the sitting president who is prosecuting him. The assertion made by Trump that President Joe Biden is involved in any way with his prosecution has been refuted by numerous fact-checkers. Additionally, on Truth Social on Tuesday morning, former President Donald Trump went on a lengthy tirade on the $464 million bond he needs to pay following the dismissal of the fraud case filed against him in New York State. Trump's legal team stated on Monday that they were unable to locate an insurance provider to cover the bond payment. They requested that an appeals court postpone Trump's payment until after it makes a determination regarding whether to uphold Judge Arthur Engoron's decision to fine the business magnate $355 million. Speaking out on the matter on Tuesday, the former president said, "Any business thinking about moving into New York State is crazy." He went on, "Many people have spoken to me about this since the racist and politically corrupt AG who started doing a number on me and my business and her corrupt puppet Judge Arthur Engoron, who has already been overturned 4 times on this case. A record started running a campaign of I will get Trump without knowing anything about me or my business." His tirade against Engoron continued apace in a slew of follow-up articles where he maintained that he shouldn't have to put up any money. The appellate division has given Engoron instructions on the statute of limitations, but he refuses to comply. The appellate division has never experienced anything like this before. Recall that this is the judge who falsely assessed Mar-a-Lago's valuation at $18 million and who has already been overruled 4 times in this particular case, a record. Before I can challenge his insane decision, Engoron wants me to pay the absurd amount. I did nothing wrong. A first. Election misconduct. Judge and AG, the corrupt political hacks in New York, are demanding enormous sums of money before allowing me to appeal the absurd ruling. Never completed previously. Happy banks, full disclaimer clause, no jury, no victim. Election misconduct. Watchin'. Until the appeal is resolved, I shouldn't have to post any money, as I was compelled to by the corrupt AG and judge. That is how the system functions. This legal lawfare would not be occurring if I wasn't leading by a wide margin in my presidential campaign. Election misconduct. Huge. Judge Engoron genuinely demands that I provide hundreds of millions of dollars in order to challenge his absurd ruling. To put it another way, he is attempting to deny me my appellate rights after I have already prevailed at the appellate division, but he won't accept their ruling, Trump stated in a different post. This is something that no one has ever heard of before. Great assets would have to be mortgaged or sold, maybe at fire sale prices, and they would be lost if and when I prevailed in the appeal. Does that make sense? Woman hunt. Undermining of election.